Good afternoon, everybody. My name is Amherst Williams. I'm the Executive Director of the Connecticut League of Museums, and I want to welcome you all to today's virtual program, Navigating the Digital Rights Landscape, Copyright and Licensing for Cultural Institutions. This is a collaboration with Connecticut Humanities and Creative Commons, who have been working together over the past year or two, in fact, to sort of think about Creative Commons and open culture here for institutions in Connecticut. And I'm so pleased to have with us today Mike Kamizis, who's the Director of Digital Humanities at Connecticut Humanities, and Kat Walsh, who is the Copyright and Licensing Counsel at Creative Commons. So Kat's out in San Francisco area right now, and Mike is here on the East Coast with us. So we have a sort of bi-coastal Creative Commons related webinar for you today. We are recording this program. A follow-up message will go out to everybody with the link and supplemental resources and things afterwards. Our guests today have a presentation to give, and there will be an opportunity to ask questions at the end after they've finished presenting. So if you have any questions as we go, please feel free to use the chat to pop them in there. I'll keep track of them and queue them up for our presenters when they're finished. Before I hand things over to Mike and Kat, I just want to remind folks that the League's annual conference will be taking place on June 2nd at Central Connecticut State University. Our theme this year is reinvention and resilience in uncertain times, and the call for session proposals is open for that right now. So I'm going to put a link in the chat. Hopefully, we've had a few brainstorming sessions. I know there are a lot of great ideas out there. If ideas come to you today as a result of this presentation, or you're grappling with ideas and questions, or you want to suggest something to happen at the conference, please be in touch with us, submit a session proposal. We have a great group of people here today, and I'm hoping there'll be some ferment and ideas that come out of it. So I'd encourage you to think about the conference as a place to share and continue this conversation. Without further ado, I'm going to hand things over to Mike.
Thanks, Amherst. Thanks, everybody, for joining us today. I'm really looking forward to presentation and some discussion about licensing and your digital content and using it and reusing it and all this good stuff. So I'm really excited to be here. I'm going to share my screen real quick before I introduce Kat. All right. Great. So Kat Walsh, who it's been a pleasure to get to know the past couple of weeks as we worked on this project, is the Copyright and Licensing Counsel at Creative Commons. She was on the Creative Commons legal team from 2012 to 2015 during the drafting and initial publication process of the version 4 of the license suite, and she returned to CC in someone messaged me, 2021, serving as Deputy General Counsel and General Counsel before taking her current role. She has nearly 20-year history in the free and open culture movements, including many years on the boards of the Wikimedia Foundation and the Free Software Foundation, and has previously worked in library policy, technology startups, and online community management. Kat is an advocate for free access to knowledge and for Creative Commons licensing as part of the infrastructure for an internet that belongs to everyone. Her work at Creative Commons currently focuses on stewardship of the licenses and copyright-related activities. And as Amber said, she is based in California. So, Kat, I'm going to hand it over to you.
Great. Thanks, Mike. And yeah, it's really great to be here talking to you all today. I'm going to start out the way that you know that I'm a real lawyer is that I'm going to say that I am a lawyer. I am not your lawyer, and nothing in here is legal advice, but I'm going to give the best information that I have to give some overview of copyright and digital media and some considerations that institutions might have, and particularly when faced with licensing challenges, both of your own material and with third-party material that you might want to use. So I'm going to start out on the first slide with a refresher of copyright. I know there's a mix of people with a variety of experience in here. So I'll give a little overview of just what copyright is and what it covers. Copyright is an exclusive right to copy, reproduce, distribute, adapt, and otherwise share almost any creative work. And the boundaries here of what a creative work are pretty broad. It's almost any work of authorship that isn't purely listing off facts or mechanical equations. So works of art are obviously covered. It's the first thing everyone thinks of. but also works of scholarship, of news reporting, even most software code is covered by copyright. A lot of historical documents or accountings, a lot of collections that people might have in museums, for example, all copyrighted works. This exclusive right is held by the author for a limited time, but legislation has increased the term so that works created today are in copyright for the life of the author plus 70 years, and works created earlier may be under a shorter term, but now copyright extends for a pretty long time. The copyright of the work remains with an author unless it's assigned elsewhere. This might be done at the time of creation. For example, a copyrighted work can be a work for hire, where the copyright might be owned by an employer, where somebody has created the work as part of their employment contract. It might be owned by a patron or commissioner who has made an explicit agreement. But otherwise, if it's not done by explicit agreement, the rights holder, the author of that work, owns the copyright. A copyright may also be assigned to someone else after creation. Someone can assign it through a contract. The author can die and the rights can be inherited by an heir or an estate, or somebody can give an exclusive license to somebody else. A copyright is automatic. A work doesn't need to be registered in order to be copyrighted. You may want to register your work in order to enforce those rights in court, but otherwise, as soon as you've created any creative work and set it down in a format such as a writing or a recording or something like that, your work has a copyright. And all works that are eligible for copyright are there unless the right holder explicitly says that they're in the public domain. It doesn't go away simply because the author fails to enforce, and it exists even when no one is sure who the author of a work is. If it is a creative work, it is under copyright to somebody, even if that somebody hasn't made themselves known. Because the rights are so extensive, this puts a lot of limits on how works of culture and authorship can be legally shared, and it can place a huge burden on speech, education, and knowledge. However, US law in particular has several exceptions and limitations to copyright that allows works to be copied even where no license has been granted. Some of these are granted by statute, such as particular permissions for archival preservation of unavailable works. Most of these exceptions are covered under fair use, which involves a four-part test to determine whether a work has been used in a way that is in the public interest to allow it without a license, even though the rights holder hasn't granted permission. And these include things such as like whether the work has whether it's affecting the market for a work, how much of the work has been used, whether you're using it in the same way, things like that to determine whether it should be in the public interest to allow that unlicensed use. And I'm going to say that I'm talking mostly about US law here. I am licensed to practice in the US, and I believe most of you registered here are from the US. International law is broadly similar. But the main way it differs is often in limitations and exceptions. A lot of countries operate in ways where the exceptions are only created by statute and they don't have principles such as fair use to kind of determine new situations as they come up. Use of works for news reporting, critical commentary, and parody generally fall under the fair use exceptions, as well as the kind of transformative uses that allow search engines or data mining to function. Use of works in order to comment on them, to teach about them, also often under fair use. It can be a little bit difficult to determine. There's often not a black and white way to say whether a use is a fair use or not. You may not even know until you go to court, but there are certain categories of works that there's so much precedent on that are broadly accepted as, yes, this is permissible to do without a license. And while copyright applies to a particular expression of a work, the underlying facts are not copyrightable. For example, a journal article might describe a historical event, and copying the text would be a copyright infringement, but extracting the facts and expressing them in your own words would not be a violation of the author's copyright. It's important to note that copyright is not always the same as norms and practices for scholarship, media reporting, or simple courtesy. For example, academic norms might require you to cite facts that you learned from a paper, even where copyright doesn't prevent you from copying them. Additionally, you may want to acknowledge your sources even where they're in the public domain. For example, you would cite a quotation from Shakespeare to inform your readers, or you might acknowledge the source of a scanned piece of data to acknowledge the work that was put in and let viewers know where they might find the rest of the collection. All right, next slide. I've given the background on copyright. I work for the organization Creative Commons, which is a nonprofit that is intended to facilitate the sharing of knowledge and culture. And one of the ways that we do that is through our suite of licenses. We have a set of 6 licenses that are intended to help authors and creators share their work. The rules on copyright that I just described seem pretty restrictive, and Creative Commons was formed in response to a legislative extension of copyright term that made those terms last even longer. People in the mainstream were just coming online en masse around the time that CC was formed, and copyrights rules didn't match up with the way that creators, reusers, and audiences wanted or needed to share. So all CC licenses are copyright licenses. They grant some of the exclusive rights of copyright, the right to redistribute, the right to copy, the right to make adaptations, so long as the conditions are followed. These licenses are still copyright licenses. The original rights holder still holds the copyright, and the work is not in the public domain. But a CC license grants permissions to the entire world without needing to negotiate an individual license with everyone. There are many places where you'll see licenses that are one-offs between a single party and a single reuser, or that have customized terms and conditions. The CC licenses were designed to make this standardized, to offer one license to the general public where you had a single set of terms that you wanted to offer. There are 6 CC licenses. The attribution license, there's attribution share alike, attribution non-commercial, non-commercial share alike, non-derivatives, and non-commercial non-derivatives. These licenses combine the 4 license conditions that you'll see the little icons for on the slide. All of the CC licenses currently require attribution as a condition, the little person symbol. It is possible for an author to choose to be anonymous or to use a pen name, but we used to have licenses that didn't require attribution, but it turns out pretty much everybody wants that. So all of the licenses require that you give credit to the author. There's share alike, which is the little arrow symbol, which is a condition based on a popular concept in software licensing, that if you build upon or remix a licensed work, which includes like making a standard remix or mashup, or even making a translation, which is one way of remixing an original work, that you must license any of your creative contributions under the same license so that others may also build on it. This type of license is often called copyleft, and it's intended to grow the commons, as the only compensation the author expects for the use of the work is that new works are also made available for others to build upon in the same way. The 2 other conditions place some restrictions on the use of the work. Non-commercial allows free use so long as the reuse is for non-commercial purposes. The wording in the license is not primarily directed toward like financial advantage. So that could cover a broad range of uses, not simply selling a work, but maybe even being used in connection with fundraising, things like that. Again, it's not a thing that has a black and white definition, but broadly speaking, if you are using the work to make money from it, that's a violation of the non-commercial condition. People who distribute that want the work to be used only for free sharing, not for things that will direct money toward you. Note that a use by a nonprofit might still be considered commercial if the work is being sold or if it's used for fundraising. It is possible for a commercial entity to make a non-commercial use if there are uses in the public interest. It's a little bit difficult. People are often asked to be conservative in considering this because so much is considered commercial activity. But that's the condition of non-commercial. Non-derivatives forbids the creation of adapted works. The work can be distributed verbatim or in excerpt, but remixes and creative adaptations are not permitted by the licenses. And any of these licenses, a licensor may grant additional permissions or terms. They may not add additional restrictions, but for example, if you release a work under a non-commercial license and you want to make a separate agreement with somebody in order to commercialize it, that's permitted, but the general public will always have non-commercial rights. These licenses depend on the underlying copyright of a work. The term of a license is only as long as the copyright term for the work. When the work enters the public domain, the license no longer applies. And using a work under limitations and exceptions to copyright, like fair use, also means that the license conditions don't have to be followed. For example, if someone makes a fair use of a non-commercial licensed work and that fair use is commercial, it's not a violation of the license because they're not using it under the license, they're using it under an exception. Only a rights holder may apply a CC license. generally the author or someone to whom the author has assigned rights, such as an employer. Someone who simply possesses a work may not actually be the rights holder. There are many reasons to prefer a CC license over another type of open content license or a one-off custom license. And I'm not just saying that because I work for Creative Commons. I'm also I've been a user of the licenses long before I worked there. The licenses have been widely adopted by cultural institutions, governments, artists, scholars, and many other creators. They're widely understood, and there's a tremendous body of work that can be reused with it seamlessly. Collections such as Wikipedia, for example, and your legal department will appreciate it. They're probably already known to your legal offices and have been upheld in court in several jurisdictions. The CC licenses offer a set of conditions that cover almost all situations where right holders wish to share their work. They're valid internationally, and they can be further adapted by adding additional permissions. You may also know about CC0, which is a public domain release. It's not one of the 6 licenses. It's different from the licenses because it is a relinquishing of all rights as far as possible. In the US, this means that the work enters the public domain. In some other countries where it's not possible to do that, a maximally permissive license is granted. And this is appropriate for situations where the rights holder wants the work to be used as widely as possible, even if it means forgoing credit and forgoing the rights to enforce any rights in the future. And many use it where they believe that they don't have rights under copyright, such as, for example, in a digitization of a public domain work, but where they wish to make it clear to reusers that they don't claim any rights in any of their contributions. And next slide. Looking at this, I believe most of you here are from cultural institutions and nonprofits, particularly nonprofits related to culture. In a lot of those cases, most of your institutions are going to have materials that are under a mix of copyright status. Some of it is going to be produced in-house by your own staff, particularly articles, blog posts. Some of you produce other written materials, such as encyclopedias or textbooks. In general, this is going to be material where you own the copyright, and you don't have any issues copying and reproducing the works that you have. Some of it is going to be third-party material, either material that you're using from another institution or a commercial provider, or things you may have licensed from other individual sources. Some of it may be a collection of materials that you have, such as an archive, and that can be a wide variety of things. Historical documents that are out of copyright, the collected works of one person that are in a mix of public domain because the term has expired and still in copyright. You may even have materials where the sources are unknown. When you're publishing online, the easiest thing to deal with is going to be the material that you own the rights to and you created. You know that you have permissions for it, and no one else is going to have a claim about anything you published. For everything else, you may have to do some research on it. If it's been licensed to you, what are the terms and conditions? If it hasn't, is it in the public domain or usable under some other justification, such as fair use? It's often not simple to do this, especially if authorship information has been lost or is missing. There are some works that are safe to republish because they are in the public domain. These are works, some where the copyright term has expired. Currently, this is anything published before 1926 in the US. Works produced by the US government are free of copyright restrictions, but it's not necessarily true for works of government contractors or even of state and local governments, even though it probably should be. And it's in the public domain if the author released it explicitly. But note that a simple statement like "this is free to use" is not necessarily a public domain release. You may have to do more research if you see materials with a statement like that where it hasn't been explicitly stated this is in the public domain. Material where the licensing information is available and there's clear permission to republish is generally not risky to reuse. For example, material under a CC BY license. The author expressed a clear intent that the work may be reused freely for any purpose as long as the author is credited. The conditions are clear. Something with a non-commercial condition, for example, can be more difficult. You'll need to check if your use is non-commercial before using it, and you'll want to consider how the work might be reused by others. Other licensed works may have specific terms and conditions, such as a license that is for particular uses only, for example, republication in print but not online, or they may be licensed for a particular term. You may use this for the next 5 years, but not thereafter. You maybe have a license that is only for a particular geographic area. I think less common now that a lot of works are republished online. But a lot of custom licenses will have particular terms and conditions that you'll need to adhere to or be careful of before you republish. Sometimes you won't be able to find the source of a work. There are a variety of situations where this happens. Sometimes it's older works where the metadata has gotten lost, like old photographs. Sometimes it's popular culture, like meme images or other viral media that travel widely without an authorship information attached. But just because you can't find the author doesn't mean it's in the public domain. These works are usually still under copyright unless their term has expired, even if the rights holders have not made themselves easy to find. If you want to republish these works, can you? The answer that is a very lawyer answer is maybe. It depends. When you're figuring out what kind of materials you want to republish, you want to consider the risks involved. The answer to, can I republish this if the copyright status is not clear, is almost never definitely not. But here's again where I say that I'm not your lawyer and I can't give you specific legal advice. You always want to consider the risks for your particular situation. For example, if you're publishing printed material that will be widely distributed and would be expensive to recall or reprint, you may want to take a much more conservative approach than if you're publishing a blog post. Something that will have a very small audience that is not going to be commercialized is going to be much less risky than material that is going to be sold to generate income. And for materials that you expect others to copy and redistribute, you might consider the effect on your reusers. If your work contained infringing material by accident, you might be exposing them to risk. It's something where you need to evaluate your particular situation and figure out what would happen if you needed to take it down or if you were going to be forced to pay damages. Fair use is an excellent check on copyright that allows us to talk about copyrighted works freely and criticize our own culture. If you're in a situation where you're discussing a copyrighted work that is not licensed to you, your best option may be to rely on fair use. But just because you're a nonprofit institution or your purpose is broadly educational doesn't mean all of your uses of copyrighted works will be considered to be fair uses. If you can use openly licensed materials or your own materials to serve the same purpose, for example, if you have a photo accompanying an article, it's less likely that you can make an argument that you needed to make an unlicensed use, and it may be best to use your own media. Next slide. So now you've thought about the risks and you're ready to publish your own materials. And you're here because you have knowledge and expertise that you want to share with others. But how do you do it? As a rights holder to works you create, you're free to choose your own licensing terms. I am a huge advocate for the CC licenses. I think they're a great standardized solution for most kinds of sharing online. But even as a huge advocate, everyone should consider what they need to happen and what they need not to happen before applying a license. For example, what are your goals for the work? Do you want it to be shared widely? Do you want it to be adapted? Do you want it to be incorporated into works such as Wikipedia, or do you want it to only be distributed as is? Was it produced under a grant that has requirements? There are many foundation grantees that now require works to be under particular open licenses, or that require them to get some income from the work before they may be shared. You should look at your grant requirements if you're getting a third-party funding source. Do you need to receive revenue from sales or licensing agreements? You may still be able to share your work freely if that's a need, but you may also consider different terms than if you didn't need to receive any revenue from the work. And should others be able to commercialize the work? In some cases where a work is going for maximal distribution or being produced in the public interest, you may be happy for others to commercialize the work in order to distribute it more widely. In some cases, you may be happy for people to share it, but you want any of the revenue stream to be directed to yourself. So these are some of the considerations. The CC license chooser asks you some of these questions before you license a work, but here's another one where you may want to consult with your own legal counsel about the things that you need from a work before you place a license on it. The CC licenses are irrevocable. If you license a work, you can't take it back later if your conditions change or you change your mind. So we do want people to consider very closely before they put a license on their work. You can also offer different materials under different terms. For example, you may have your blog posts under a different license than the print materials that you put on. You may offer additional permissions if you apply a CC license to a work. For example, you may have most of your works under a non-commercial license, but offer a commercial license for a fee. In any case, making things clear to reusers is key. You should mark your works with the licensing information so that you don't encourage others to unintentionally infringe your rights. So next slide. Many of you are in the position where you're publishing materials that is a mix of materials that are your own and that come from third-party sources. And one of the topics that has come up is takedown requests. What if somebody claims that you have infringed somebody else's rights by publishing a work? The best situation to be in is one where you don't get one at all, or where you know that any request can't be legitimate, such as by publishing your own works, which is why I mentioned the rights for licensing your own works. It's always best to use material where you're absolutely sure that you have the rights, because dealing with a takedown request is no fun, even if you know that you're in the right and that nobody else has a claim to it. But if you get one, the first thing is don't panic. And you may also want to contact your lawyer if you haven't access to one. Even if you're sure you're in the right, it's best to get good advice to make sure that you're making the right steps in the situation. You should check to see if it's legitimate, especially from stock photo sites and aggregators. It's entirely possible that the person sending the request is in the wrong, and you do have permission to use the work. This is where it's useful to keep good data about where you got a work and what its terms are. Maybe you're including information about the source whenever you republish. Maybe you have a spreadsheet or other central place where you're keeping rights information. My first legal job was actually at a publishing house where there was a giant file cabinet of all their rights and permissions contracts, so they were always ready to show what they had. But if you have good information, you're in a better place to evaluate whether a claim is legitimate and whether you do actually have permission for a work. A lot of stock photo sites and aggregators get submissions from third parties that may themselves not be very clear about where a work came from. They may think that they have a claim for a work, or that somebody authored a work when they didn't. So if you have good information, you're in a much better place to contest it, because it's not uncommon that their requests are actually wrong, and you would have the rights to use the work. It was either licensed to you or it was openly licensed. If you know that it is public domain or openly licensed, you are using the material legally and you wouldn't have to take it down. It is also possible, though less likely, that the sender of the notice is simply trying to scam you. It is less common, but sometimes people do make completely fraudulent claims just in hope of getting settlement money. So if you have good notes, you'll be able to identify those when they come. Another claim is that you were using the work improperly, and you should check to see if you followed the terms of the license agreement. Did you acknowledge the author and any sources as required? Are you following the additional conditions? Sometimes rights holders will also make mistakes here, particularly if they're finding infringements with the aid of automated services. But if your information is not obvious, say if it's not clear where to find the credit, if you followed the terms, but it's not clearly attached to the work, now is a great time to make sure that it's really clear that any required credit is included where a reader might find it. Do you have things that were submitted without oversight by a third party? If you have forums, community submissions, or comments where the public can submit material, you're not liable for somebody else's infringement if you take it down when you receive a notice. If you're using the material under fair use or another exception or limitation, this is riskier because you're going to have to make an argument that your use is legitimate. I would love to say that you should simply leave it up and fight for your rights to free speech, but this may come down to a practical decision for you. Is it worthwhile to you to take the risk? If you have a strong justification for using a work, particularly something that you're using for critical purposes, it may be important to you to leave the work up. But it's possible that the rights holder will disagree with your assessment and bring the fight to court. Whether you should pursue this argument really depends on the situation that you're in and how many resources that you have to fight any such claims if you believe that your argument is legitimate. Since it's very hard to make a determination, it is always possible that it could not come out in your favor. So this is something that you should consider along with your legal counsel and leadership. But unfortunately, you may find out that you were in the wrong and the takedown request is real. You accidentally infringed somebody else's work. You should minimize damage and take down the material. You didn't want to be infringing in the first place, and you definitely don't want to after it's identified. You should take a look through your other materials. How did it happen? Is there a particular source that you thought was permitted that isn't? Were you using materials where you accidentally pulled from a commercial source without permission? This is a good place to audit your practices and see if there is anything else where you might be liable. Almost nobody wants to bring these things to court. Court is expensive. It takes time and money to fight it out. The usual thing that happens is that the rights holder wants a settlement payment. Some people who are doing the search rolls and they're simply looking to extract a maximum payment for everyone, mostly not. In this case, you might want to try to negotiate. You might want to research commercial licensing fees. For example, what does it usually cost to license the work? You should be aware of statutory damages for registered works. Someone is entitled, if the work is registered with the National Copyright Office, to a certain set amount of damages under copyright law, and that is a point that they may use in order to make a starting point for a negotiation. So you may not be able to negotiate it as low as you like. Again, this is something that you should do in concert with your legal counsel, but it is a position that you should be aware is a consideration. You can negotiate down because they don't want to go to court, even if they are in the right, even if they are going to win. It's still much more expensive to go to court than it would be to accept a lower settlement from you. But it's best to avoid in the first place by using known rights cleared material, material that you produced or that you know you have the rights to use. So next slide. There are alternatives to using commercially licensed images and images, other creative material, any third-party material that you want to publish. There are some great free sources out there. One of the largest is Wikimedia Commons, which has a large collection of freely licensed material, mostly images, but all kinds of material. Flickr Commons, which is a special collection on Flickr that includes freely licensed material, a lot of public domain material, particularly contributed by cultural institutions like yourselves. The Internet Archive, which allows public submissions. Licensing information is included on all of the pages on the Internet Archive. They are public submissions, so you may have to vet some of it for yourself, but it is an extremely large collection of media that is free to reuse. And also public domain and historical collections, some of your own. There are collections such as Europeana, which have a search engine for all sorts of freely reusable material. There are free stock photo and clip art sites, which often have very permissive licensing, which allow commercial use for things like newsletters and commercial republication. But sometimes you do have to be careful about terms. Most of these sites have custom licenses that are specific to each site. In particular, they may not allow you to republish an entire collection or more than a certain number of works. They may require links back. It's best to, if they're not using a CC license or other standardized license, to examine the terms and conditions carefully to be sure that they're suitable for your use in any reuse. Creating your own works is always one of the best options. You know that you have the rights to them. If you have the resources in-house, that's a great alternative to looking for a stock photo. And now there is AI. You can use DALL-E or one of the other generative AI programs to generate art. That is possible, but there are some considerations. The output of these systems in the US so far has generally been considered to be uncopyrightable. There is no human author behind the creative work. The output may be public domain. There are some asterisks here. Depending on the prompt you give, you may have accidentally reproduced some copyrighted works. For example, if you ask it for something with Mickey Mouse, you may actually get Mickey Mouse out. This is a bad example now. Old Mickey Mouse is out of copyright. New Mickey Mouse, however, still under copyright. Super Mario, if you ask for Super Mario and you get it out, that's still copyright Nintendo, even if you ask AI for it. So you'll need to use some judgment about what came out. You may also risk public perception. A lot of artists and creators and a lot of the public are very skeptical about the use of AI, and if they suspect that something has been AI generated, you may take a reputation hit for using an AI generated image instead of something that you created yourself. That said, if you need something quick, or if you were trying to explore an imaginative idea and you don't have the resources to have an artist do it, you may want to use one of these AI systems, and the likelihood is that this will be an option that does not present copyright problems for you. Uh, so the next slide is just a thank you, and I didn't see any super burning questions in the chat, so I hope that I can address some of them at the end of the session. And I will hand it over to Mike, who will have his particular example from Connecticut Humanities.
Thanks, Kat. That was great. Give me 1 second here to pull up my presentation. I made some notes to connect to some of the things that you said. Specifically, were in our deliberations. So I'm going to share my screen. Great. Are we okay? I think we're good to go. Hi, everyone. Again, Mike Kamisis. I'm the director of Digital Humanities at CTH. I've been at Connecticut Humanities for about exactly 3 years now. My background is in library and archives. I was working with the Connecticut Digital Archive before my current role. And I have moved up through the organization and now run our digital humanities projects. And we're known for ConnecticutHistory.org and Teach It. And we're also building out to support the cultural digital infrastructure of the state. So I'm going to walk through one of the bigger projects that we undertook, which was licensing ConnecticutHistory.org, or should I say relicensing ConnecticutHistory.org after years of kind of being unsure about what we should do with our content and moving forward. So, I'm just going to be echoing a lot of what Kat just said about, why Connecticut Humanities undertook this project and what were our considerations. First of all, as Kat said, reuse. We really don't want people contacting us every day asking how and if it's possible to use an article that we've posted in their research. We want to make it clear for people to understand what they can do. We want our content to be reused in certain ways too, and we'll get into the considerations for that as well in a little bit here. But at the same time, we want to protect ourselves, right? The way that we produce content at ConnecticutHistory.org is we contract authors. We pay people to publish. So we own the copyright to this content, and we want to make sure that it's used in a responsible way, but we also don't need to check up on everybody that's using all of our content. So as Kat said, the legal backing of the CC licenses plays a big part here. We know that we are doing something responsible by licensing our content, and that if we do find any kind of infringement, we can fall back on the licenses as the first line of defense to really get at somebody who's not using the content in the way that that we don't want it to be used, which doesn't come to my front of my mind. I can't think of an egregious example, but that doesn't mean that they can't take the history that we're putting out there and using it in different ways. And then also the big part of this is putting everything that we believe into action, our dedication to open access. About 2.5 years ago, CT Humanities adopted an intellectual property policy across our grant lines, most of our grant lines, about making sure that the content that's produced using our funding is as accessible as possible to the citizens of Connecticut and beyond. And that the next step after that is really promoting open access. So we want to set an example for organizations in the state about how we can go open responsibly. And this is part of this, is explaining what we're doing. So as an organization, we're dedicated to open access. And the first step we're taking is to appropriately license our digital content. Okay, so what is a concrete example, how did we go about determining what license we were going to use for ConnecticutHistory.org content? During our research, and I want to give a shout out to my colleague, Emma Wiley, who's the Digital Humanities Content Manager, who did a lot of background research on this. We found that our content was previously licensed up from the beginning. So ConnecticutHistory.org launched in 2012. And until the site was redone to how you see it now in 2018, everything was licensed. Licensing was baked into this program since the beginning. It got lost in a transition to a new site. So that also puts some murky waters there. As Kat said before, licenses are irrevocable. We've licensed more than half our content previously, and we do not really remember how we licensed them. We have a good idea of what the license was across the site, So that was a consideration that we had to take into account as we were going through this. We did find that through the Wayback Machine, through archive.org. And we were looking back at some past articles and someone said, hey, this was licensed. What did we do? What happened? The other thing that was big to me professionally was we wanted to be as open as possible. I wanted the license to be designated more towards the open culture license, and Kat said the copyleft license. I wanted as minimal restrictions as possible on the content while still balancing protecting our intellectual property. So we had some discussions on that, and that included discussing non-commercial use, which led to our discussion about the current contracts we have and the contracts we signed in the past with authors. We have over, like 13, 15 years of contracts with people that write for us, and the conditions are about the same. So if we use different considerations or use a different license, how would that impact the contracts we've signed, and what are the unintended consequences of, for example, using a non-commercial use? And we found out that would maybe prohibit people from printing in a journal. We don't know. It depends how the journal's set up. We want the content to be reused as much as possible by us, by researchers, and by the authors themselves. So we came down to choosing the Creative Commons Attribution Share Alike license, and you can see the little logo right here as our license for everything we own on the site. And I'll get into that in a second, why I have to qualify what we own on our site. We did this for a number of reasons. It's open. Share Alike really prohibits commercial use. You really have to think about it, how you're going to commercialize something that needs to be shared under the same license as this. And second, it is a less restrictive license than our previous license. So our previous license was attribution, share alike, non-commercial. So if someone were to find that old content for somehow, any way in the old site, and then found we relicensed it, we wanted them to be able to use a less restrictive license. It's really unenforceable if we even got more restrictive and say had like the most restrictive, no derivatives, non-commercial use, share alike. We really couldn't enforce that on older content that someone had found previously under a different license. So now we want people to be able to use it even broader. So we figured out that this license works. I just want to say this is a part of a larger sustainability project for ConnecticutHistory.org and Teach It, which we'll get into in a moment. That includes new ways that we review content, new ways that we handle takedown notices. We needed policies and procedures and infrastructure put in place around the program of ConnecticutHistory.org. This is one of the core tenets that we needed to do to really do some of the work we wanted to do to connect people to resources and tell really great stories about Connecticut. So this is just a little bit of our timeline, what went into it. So I'll start in the middle here. We launched our new licenses in October to coincide with Open Access Week, International Open Access Week. But we've been working on this for over a year, really. Back in 2023 and early 2024, we did research into how do other state encyclopedias approach this. Not many have something like licensing of their content beyond kind of all rights reserved. I think we found 4 or 5 organizations. Again, how does it impact our author? What about the content we don't own? ConnecticutHistory.org has a lot of republished content from Connecticut Explored, from the Connecticut Museum of Culture and History, from CT Public, NPR. So how do we handle that? We have now we're making another problem of a whole bunch of content we don't own. Granted, it is explicitly stated we don't own it, but now we have to manage that differently. So what do we do? And what about images? We'll get into that in a little bit. But what do we do with the images that aren't ours? And Kat had mentioned that it's easy to use your own images, but our goal is to use the images of the collections of the collecting organizations of Connecticut. What do we do? How do we do that? And we did that by developing policies and procedures. This is my bread and butter to kind of build up an organization. I know it's not flashy, but it's really the bedrock for all of our work. So we created a policy, or Emma actually created a policy on the reuse of content. And I can share a link out after this about what are we stating that we have the rights over? How do we want you to reuse this? How do you cite us, right? There's a big, in Creative Commons, they have a big kind of best practices on citing content. What do you do if you think that we're using something that's not in copyright? So we also have a content removal page that fits in here too. So it's about our takedown policies and procedures about how it gets reviewed, who makes the final call, what the timeline is, things like that. We haven't had to use it I'm hoping we never do, but we have it there just in case, that really transparent about how we handle this type of stuff, which includes involving the editorial board of 13 independent scholars and community practitioners around the state who really give us that kind of backing and authority. And then currently, what are we doing? We're reviewing our content to tighten our scope, talked about all the content that's not ours. We are taking that down. We just can't manage it. It's too much. It's carving out this whole other bubble of stuff that we have to consider when we're moving platforms in the future, kind of future-proofing ourselves. As Kat said, we want to work with our own content. It makes it the easiest. We know we own it, so we can do different things with it without other considerations. And then we are also reviewing images for a couple of reasons. One is we want to attribute properly. So if we do get a takedown notice or something, we want to be able to fall back on maybe some sort of fair use, whatever the situation is, that we always want to link back and give proper credit to the organization, because we're trying to illustrate our articles. So that's a big project that's going on. We found the really egregious ones and have fixed those in terms of takedowns and things like that, but it's a never-ending process that we'll keep going on until we feel good about it. So as I said, we're moving towards creating a sustainably open public humanities platform in Connecticut.org. So we are clearly communicating, we are licensing our written content. That is all we're licensing. We're not claiming any licensing over any of the images that illustrate our articles. That's in the license itself. We say that on the bottom of every web page, right? So you can reuse our written articles. You got to go figure out if you can use the images yourself. But one way that we're working towards making it more sustainable for us as an organization is we have a preference to use openly licensed images or collection material. I am hoping at the end of all of this, in the next couple of years, we won't have to go get image license agreements. We won't have to pay for images. We can use the CTDA, we can use Connecticut Collections, we can use the National Archives, and they're licensed. And we know exactly what we can do with them. So we don't have to jump through hoops and try to figure out and pay for we paid a lot for 5-year licenses back in the day. I don't want to do that. That's a lot of work. And for us, we're trying to streamline the process and also push people to say, hey, you want to be involved in our project, we really value open, you should probably do this. So I think in the future, we had a couple examples recently where it's either, hey, you can pay us for these images, or we found some free kind of public domain images that we knew were in the public domain. We use those instead. And then in technology, for us going forward, licensing and having that embedded in the technology is a core requirement going forward. So when Connecticut.org becomes whatever new site it becomes, one of the first questions you have for developer is, how do we denote rights? What is your rights widget, plugin, whatever, because that is important to us. So quickly, I know we have about 10 minutes left. I just want to give everyone here some ideas about the next steps that we're doing as an organization. Teach It is our other big digital platform. That's got its own considerations that we are working on. And hopefully this spring, we will start the same process that we did for Connecticut.org to examine how to become a truly open educational resource. Right now, it is murky. We're going to go through and do the same steps and same processes to start the conversation about Teach It so that people know exactly how they can use it in the classroom or beyond. Again, we're doing image reviews. We're fixing and replacing images and captions so that we feel a little better about where we are. Again, as Kat said, it's all about the risk we're willing to take. So we're going to do that kind of image by image sometimes. Connecticut Humanities is hopefully going to look at adopting an open access policy as an organization. We have an intellectual property policy. The next step, as I said earlier, is a true open access policy that goes beyond kind of this project and really embeds as a funder what we believe and what we want to advocate for. Another thing that we're stepping into is open access publishing. So this is kind of something that the Digital Humanities Department is doing, finding scholars to work with, supporting local journals, either financially or through consultation. We see a need for open access publishing in the state. And we're working to make connections there and testing out a couple things right now that I'm really excited about. We'll continue to keep offering more education, more webinars like this, more opportunities to meet with people from Creative Commons. We also want to put a flag out there that, like, hey, we're here to do consulting. Again, not lawyers, but we can put you in contact with people or give you resources and just really talk out some of the considerations even further than we did today. And then keep working with the Connecticut systems, the cultural systems like Connecticut Collections, the CTDA, Connecticut's Archives Online, to embed these licensing options into their technology. For the CTDA, for example, they use Creative Commons licenses and rights statements. So I think both of those together really hit on a lot of the scenarios that people with collecting institutions in the state run into. That's just my quick example. I'm happy to talk about this more. We'll send out our contact info after this. But I just want to say thank you for joining. Thank you to Kat for that great presentation. I know we had a lot of discussion about takedown notices. I know that's a big thing. Yeah, so feel free to reach out to me or anyone at Connecticut Humanities. They can get to me for copyright kind of questions. So I think now we can open it to questions or comments.
Yep. I haven't seen anything come through in the chat. So I'm going to put this in a gallery view. You can, if you could use just because I have multiple screens here, if you can use the Zoom raise your hand option. If you have a question, I will call on you. Or you can pop it in the chat if you don't want to speak.
I know there's a lot of information. And this came out of a concern of ours that Connecticut Humanities got hit with a takedown notice over an image from some aggregator that was sent to us from, we think from a grantee organization. And, I think that's still going on. So we wanted to, in our discussion, our executive director and our board members were saying we can't be the only ones that have been hit with something like this. So, we're happy to talk more about that and happy to make connections to people who might be helpful. And that's what we want to do with Creative Commons.
I also want to bring up a public service that we do at Creative Commons. On the third Friday of every month, we have an office hours, and I'll try and find the link for that and drop it in the chat. But anyone can drop in if they have a question about CC licensing or open licensing and copyright. And it's just an informal session where I'll be there to help people talk through problems. I can't give you legal advice, but I can help you talk through the principles and considerations that you might have.
Joanne has a question. What sort of message should we add to our website where we have our old newsletters available?
So, the easiest thing just from not knowing anything else is you could probably license them and just, I don't know, Kat, I know there are tools to embed licenses in your site so people can read them, then computers can read them too. So you do aggregators and things like that. We don't have that ability right now. We just have an image on our site that says, here's the license that it's under. And I think that's the best that we can do right now, and it's better than nothing. So maybe you want to look into licensing them. So if you want people to reuse them, how you want to reuse them. I think, if you created them, again, depends on what kind of images you use in them, that kind of stuff. You could go all day. It's like, well, what do you want to do? What's in them? Licensing might be a good way, even if you just download a license logo and put it under the web page or something like that.
Is there anything you want to add, Kat? Joanne, I think a part of it is just first a conversation with others at the organization about, how you want other people to be able to use that content, if at all. And then, the Creative Commons licenses give you some good gradients, kind of a good gradient for thinking about what that could look like in terms of a statement on the site. There's some just like thumbs up, great presentation feedback. Jocelyn has put in a link to the Creative Commons licenses page that describes the ones that Kat talked about in greater detail. Diane's advising people to be aware of random takedown notices because some may be just phishing scams. So, be thoughtful about how you respond to those. Lorianne from the Glebe House asks, is it usual for different platforms to disagree upon whether or not content needs to be taken down?
Oh yeah, I'll take this one. I think the answer to this is yes. And it's just because everybody is doing their own risk assessment about like what's the risk to them, what's the benefit of them. Some platforms are like, no, we really think this content should be available and the claim is not legitimate. And some platforms will say like, no, we just don't want to deal with any of this. Anything that causes trouble, it's not worth it. So it's definitely depending on what kind of platform it is, we'll have different opinions.
Thank you. Deanna asks, when a copyright holder is unknown, is it satisfactory to document all efforts to identify the owner before publishing?
Yeah. I think it will put you in a better position than it would if you hadn't. If you're using a work that is under copyright, it's still not completely safe. Like a rights holder could come out, but if you've done your best effort to identify the rights holder and you can't find them, it may mean that they're not actively enforcing their rights. They may not even know that they own the work, particularly if it's owned by an estate, somebody who died and they left it to somebody. Uh, you may still be liable for infringement, but I think if you documented that you used your best efforts and you had a need to publish that work and you did, you're in a much better position to prove that you tried to do everything you could to comply.
Judith asks, we link a lot of our partner projects. Are we liable for their images, et cetera, just by linking to them? Or is this not something we need to worry about?
Yeah, and this is something that has come up in court in the U.S. and in general, if you're simply linking to something and you haven't actually made a copy and republished it yourself, you are not liable for infringement because you did not make the copy. You're just directing people to somebody else's copy.
Great. Thank you. Elizabeth asks, if donating a work created by them, does someone who is under 18 have the right to give a repository the rights to their works?
Oh man, this is a difficult one because I believe that technically the answer is no, that minors can't enter into contracts in the United States. But there has been almost no litigation about people trying to go back on those contracts. And then when somebody becomes 18, like they're basically you and they don't rescind those contracts or they can validly enter them. It's usually safe at that point. But I would say this is an area where you might do a risk assessment, like you might ask children to get the consent of their parent or guardian if you're getting material contributed by minors. It's probably low risk, but it's something where you need to consider your particular situation and what happens if things go wrong.
I muted myself. A couple of questions from Akshay. This one's to Mike. Is CTH also specifying license for website code?
No, we are not. We are not in the business of developing our own websites. We actually contract out for that. So we want to go as open source as possible, which is part of this whole conversation, open source software, but we are not in-house developers. We use WordPress right now. So we're not claiming license over them.
And for Cat, do Creative Commons licenses cover that as well?
So we will say that it's possible to CC license software, but in general, we recommend that you license code under another free software license, such as the GNU GPL or the MIT license or something like that, because it helps. Most software is under a software license that is specific and has requirements around how you share source code and to be more compatible with those so other software developers can build upon your projects. If you want to also license under a CC license, particularly if you have like design or creative elements, you can do that too. But for open source code, we do recommend us an established software license.
Great, thank you. Bush S asks, we have a collection of letters from armed forces members in World War II. What do we need to consider before being able to write about and quote those letters in our newsletter?
Yeah. For that to write about and quote them, that should be covered by exceptions and limitations to copyright. So the copyright considerations would probably not be a primary concern there. Most of those people are probably deceased, and their estates probably are not, enforcing the rights to their letters. So that I would think like your social and ethical considerations would be a much bigger consideration than the copyright to those.
Yeah. And if these are things that you have in your collections, presumably, like you have, I mean, this is not always the case, but if it was accessioned in a proper way where they were given by a donor, you have at least some, purview over those materials as the organization. So there was a rather specific question. We're at time, but I know that Kessie had a couple of really specific questions, and I'm wondering if she and you, Kat, might stay on so that she can ask you directly. But I want to thank everyone for being here, for your excellent questions. I will be sending out a link to the recording, the slide deck, and some follow-up resources. So I want to thank you all for being here, and a special thanks to Mike and Kat for their time and expertise. And we'll be sharing information on how to reach out to them as well if you have specific follow-up questions. Thank you for being here. Have a wonderful afternoon, everyone.
Thanks, everyone. Stay warm.
Kessie, I don't know if you can stay.
Yes, I'm saying thank
Okay,
you.
great.
Thank you for saying as well.
I just figured we might as well take the time. If Kat can stick around for a couple of minutes and you can too, maybe you could just ask your two questions directly.
Yeah, sure. Well, I'll read my message. So,
Yeah.
so I'm currently working on populating an online platform, and we are on the starting stage. So it's a WordPress platform, and the goal is to host and provide access to publication related to Haitian studies. It is for a non-profit organization, so we do not own right to those publications, and to ensure the compliance with copyright policies, I would like to clarify, are we allowed to simply repost open access publication from other websites and other journals on our website? Or do we need a specific license to do so? And for the publications that are not open access, we thought that we could perhaps ask for the accepted manuscript version directly to the authors, and we wanted to know if that was something that was okay to do as well.
So if you want to republish open access publications, provided they're under the kind of open access license like a CC BY license or a BY share alike, you're allowed to republish those, like as long as you're following the conditions, which are usually like you give credit, you acknowledge the source, but otherwise, like yes, you're allowed to republish them if you've gotten permission under those terms. You do want to check the licensing information to be sure, but most of those publications do allow you to republish. For things that are preprints is a whole interesting field. I think a lot of that field kind of acts where the publishers kind of pretend that people aren't sharing them. Some journals don't mind if researchers share preprints, which are the manuscripts that are but in their version before publication. Some publishers do mind. Um, so a lot of them, a lot of them get shared like through email and just among researchers themselves, and pretty much this is ignored. But if you're republishing preprints, if the final version has been if the final version is in a journal that forbids that, sometimes the researcher will have openly licensed that preprint, but the final version that appears in a journal will be under a restrictive license that's not open access. That one may be a little dicey. That one's actually probably on the researcher who signed a contract with a publisher that they didn't really intend to follow. That they said they were giving them the exclusive rights and they didn't really. That's in theory that shouldn't be your problem, but in practice that may be your problem because the researcher may go around and try and take those back and try and unpublish the preprints. It's much easier to republish things that were open access and the final versions are open access. I don't know how much that answered your question, but it's a little more complicated situation. Since the final version and the preprint are usually substantially the same, they contain a lot of the same material. When the researcher is licensing that to a publication, they may be saying, "Oh yes, I've given you a completely new thing, and you have the copyright, and it's under a restrictive license," when actually they have this other version out there. So they're probably in violation of their contract with the publisher. It's not it's not your fault that you got a thing that they claimed that you had a license to. Like you probably would not, you shouldn't be liable for copyright infringement for that, but it still may be a mess as they try and get it taken down so that they don't jeopardize that relationship.
Okay.
I think, and I'll just jump in because we're working with a local journal that is totally behind a paywall and looking at the different contract options. There's some that allow preprints, but only through like a gate, like you need to sign in when you're on campus or you have the access to, versus like the some of them, depending on the contract, same publisher, different contract. Well, I forget the exact name for it. It's gold OA, green OA, all that stuff. Will allow them to put a preprint that's not locked down, that's not gate kept. Some of them say you can only put in your institutional repository, but it's only accessible to your community, right? And so that it depends how you get it. And I'm not sure if you're a scholar or not, but I know I talk to a lot of scholars. I'm like, well, I can get this article. It's like, how did you get in? Well, I'm on campus. It's like, I can't. And that's the other thing. So you might, how you get that. And in addition, I default to Kat on this a lot about the licensing, but it's on the author to understand how to share it properly. So that's another consideration I have, especially since we talked to journals. We're also doing an open access publication. We're dealing with poets, so a little different. We've made the decision that anything that's in the public domain, we will reproduce. Anything that is in copyright, even if we can't tell, we're just going to link to go to that other question. Like we found it online, accessible through another vendor who has a agreement with like JSTOR to publish something. So we'll point people there. I don't know if that helps or not, but like that's, we're navigating some of these things too. We made the decision not to license or pay for this content. Like we won't go into an agreement because we want people to use it. And if we pay for it, it's only good for us. So we'd rather promote, push people to resources that are open.
Thank you. Thanks for the clarification. Naively, I assumed that manuscript was the author or the scholar a property, so they could share it as they wished. But no, thank you for clarifying.
Great, thanks. And if you have follow-up stuff, I think that Mike and Kat are going to be sharing their email addresses. So great.
Thank you.
Yeah. All right, well, I'm going to stop the recording. Kat and Mike, if you want to just stay on for a couple of seconds, we can talk about follow-up resources. Thank you, everybody.